is a brand new day, and we'll be making history. Are you with me? Won't you stay? We have come so far. This is who we are. And like the rising sun, we have just begun to play our part. This is the time we form the chorus. Lift your voice for those before us. We can rely on one another. Feel the pride, let's show our colors. We are heroes and dreamers. We are restless believers.
Good morning, good afternoon, good evening, whatever time it is, wherever you are. This is Gail of Gaia, and this is Free Range, where we graze on wild ideas, and we have wonderful guests. And today, we're going to learn something about a very important document that is, at times, seems to be hanging by a thread, but that's because people aren't using it. And we're going to go through using it. And Dwane Kirkland is a Constitution advocate, and let me bring him on. We also have another guest in the studio, but she's having some internet problems at the moment, so we'll bring her on if she is able to come on. Her name is Eva Marie. Let me see if she can get up. So, and let me remove this thing right here. Okay, Dwane, let's talk about this. You have Bill of Rights office. Why don't we talk a little bit? Why don't you tell us more about yourself? The only introduction I gave was a constitutional advocate, and you're also you help people. You've helped me, and we'll go through a document that he helped me with, that he did. So yeah. It's awesome.
Yeah. Well, first of all, my name is Dwane Kirkland. I'm a self-claimed constitutional officer and also an advocate and many other titles of nobility in behind the scenes. But actually, the most powerful title I have is a witness, helping people with dismissals, grounds, and paperwork, filing objections, and whenever they are under scrutiny and being violated. So a lot of people call me for help, and I teach them and show them how to use the Constitution as a weapon to drive a wedge between all the wrongdoers that are ganging up on an individual for a victimless crime. That's pretty much what I do, and I teach. I basically teach constitutional law to teach people that the Constitution is an ironclad contract that is withstanding in a court of law. And a lot of people don't know that it's actually enforceable in a court of law. And a lot of people don't know that the constitutional supremacy law of the land, a lot of people don't even know that it actually is supreme law of the land, like the Bill of Rights and constitutional amateur prudent constitutional law and a bunch of other different types of case laws that is considered supreme law of the land. So I'll leave that at that short take, and that's basically all I do. I just help people across the nation behind the scenes.
All right. I'd like to let the audience know that I believe they can ask questions on Freedom Range, D-Live, or Twitch. One of my channels on YouTube, they took a video down that I did with Dennis Mill, and we were talking about similar things. So anyway, moving right along, what we could do is go through one of the documents that you helped prepare.
Okay.
On my behalf, because I don't know what I would have done without some help. And I actually know quite a bit about this, Dwane, because I've studied it in the past, but I've seen so many things not work by others that you get a little gun shy, so to speak.
Right. Unfortunately, in the court system, we've learned from experience that the lower courts pretty much don't comply to their oath of office or even the Constitution nowadays. But that's actually changing to the good, believe it or not. They seem to scuttle it or ignore it until you get to the higher courts, which like on an appeal process or even higher than that. But there's a lot of tricks and methods you can apply in that could be in your favor, because a lot of people don't understand that the fundamental principles, the amendments, the provisions, the articles, and the declarations of rights is actually supreme law of the land, and is actually in harmony together. And if you don't know it, it's what they say it is. So the reason we're having problems is a lot of people don't know that. They don't even ask questions, or they don't even try to utilize it and keep it simple. I see from experience of the phone calls and people that I help that come and ask for help for me personally, they make things complicated, and they're doing so much stuff that's just way out there when it's so simple from the basic civics of government. So it's really simple. There's only 7 articles in the Constitution, and each state has declarations of rights, which their declarations of rights at the state level is actually their Bill of Rights for each state. So they're actually in harmony. If you read one and read the other and you compare it, I usually take 3 of them, pull up the state's constitutions, and then read the Declaration of Rights, and you'll see most of them are in harmony. The ones that are out of harmony are the ones that fraudulently made changes. Somebody made changes in there illegally, basically, and they're actually violating the actual laws that are in harmony and the protections.
I think it would be important that we explain what is the difference of real law versus color of law.
All right. There's a distinctive difference between real law versus fake law. Real law is supreme law of the land. Okay. And the supreme law of the land actually says it at a state level. They have their supreme laws at a state level. Okay. Now, fake law is when laws that are passed. First of all, you got to know who makes law. First of all, right? And that goes right down to basic civics. So if you know the distinctive difference of how law is made, then you can pinpoint if it's real law or not, or even question it through due process. So any laws that are made that are in conflict with your fundamental principles, your amendments, your provisions, your articles, and your declarations of rights, actually, if it's in conflict, it's not law at all. It's legislative fiat, and it was made to be law, but it's not really law because it was never passed. They might have passed it, but it can't be passed as law because there's a conflict of interest, and a lot of people don't know that. And it goes right down from this. It goes from, just like in the 10th Amendment, it says the power of the federal powers, and then if the federal powers are violating, then it goes down to the state. Power goes back to the state. The state violates the powers, goes back to the basic individual, right? You heard that, right? In the 10th Amendment, or basically. So
Yes.
So anytime there's a conflict of interest, if they are actually, the federal part is violating it, it's supposed to go to the state, and the state, if they don't make the corrections and fix it, then it goes back to the individual. And so as we individuals, we can actually declare a law conflicting. And there's some people that say you have to go through the due process to do that, but my teacher taught me and said, if you have the good argument, and if you know the argument well enough, you don't even have to go to court over the issue. You can just file an argument to the prosecuting attorney and show your argument, and it won't even go any further. They usually drop the issue or whatever if you can convince the prosecuting attorney. So really, the prosecuting attorney is the one that convince, if you can actually keep them separated, not all of them ganging up on you. But there's a trick to that too, so that I've learned on experience. So,
well, I think what people don't realize, and one of the ways that our justice system has been weaponized against us, is there's money involved.
Yeah. But thinking about what you said, that you said about the real law versus the fake laws. Let me give you an example. Say you walk into DMV, right, and they hang a sign up, and they hang a sign up saying you got to wear the mask, or you can't carry a gun, or whatever. Any law, somebody in that office that is a authority figure in their office wrote. It's really a proclamation. Fake law is a proclamation, like coming from a king, if you really think about it, right? It's a proclamation. Yeah. Somebody writes it, hangs it on a tree, and they're telling you to obey it. The same concept when you walk into a building, they have a rule or regulation up, or a code or a statute. Nobody ever questions it. You don't question it. You just do. When you walk in there, you say, oh, I have to wear a mask. I'm going to wear a mask, right? But if you know that it's in conflict Huh?
I said I didn't, but I got one of
Well, yeah,
those things
there's a
for
lot. There's a lot of us that didn't because we know it's a
better.
conflict.
Yeah.
It violates our free basic agency to choose. Right. Not only does it violate that, it violates the real law. I mean, it
Exactly.
violates. It's like that's. I mean, I can elaborate way on it, but it's law is law, real law, and there's fake law, and the fake laws can be made by anybody. It can be made by an attorney. It can be by just like the Supreme Court or the judicial system. Court can make, like, I'll give you another example that I found out from the auditors working behind the scenes, behind them typing and giving information while they're auditing and filming. Uh, they'll go into a courthouse and then they'll say, well, they got a court order from a judge that says they can't video or record inside the court, right? Well, if you
Yeah.
can't record and video inside a court, how are you going to convict a judge for violating somebody's rights? Because it's you can't see what they're doing. They're blocking what you when they're doing wrong. They don't want nobody to see it.
Censorship.
But right, so the judge writes a law, and when you write it, and really the judge can't write law. He's the judicial part. He doesn't write law. Period. He can write some orders or rules, but if they're in conflict, then there's a conflict of interest, then they're void and null automatically. But people don't know that.
Right. Well, we have a conflict that we could actually go through based on the right to travel.
Right.
The work that you did for me. If you would like to go through that, we could.
Yeah. Do you want to read a document part and break it down, or do you want me just to tell you what I know about the free to travel? I mean,
I think it would be good if we went through the document and then kind of discussed it as well. I think that would be helpful for people.
It's better to read the documents that I created, and then I can elaborate, or you got questions on certain parts, because I don't have a photographic memory. I get the Holy Spirit once in a while, and it'll flow through, and then sometimes I have a brain cramp, but really,
hey, don't we all? Yeah. Okay. Do you want to bring it up on your screen, or did you want me?
Well, I'd like to. You know what I'd like to go over is a dismissal on grounds. Is the main purpose of what I want to go over. That I wrote the dismissal on grounds for you.
Okay.
That's a public document I created for the masses. So I'd rather go over that and break that down like we did when we were on the phone. That traveling thing could be a whole nother issue.
Okay, let's hope that I can bring that one up. So go back here, and somehow I have to bring it up on this in this browser here. So that's the only thing. I have the other one. I have the other one, but I don't have this one ready.
We'll bring the other one up. We'll go over the other one. That's pretty much the same, except for it got to do with quashing a warrant. So
yeah, well, we can start on that, and I can look for the other one as well. But
yeah.
Okay, and you can talk a little bit while I see if I can find the other one.
I wanted to go over the ones that we got numbered. That's numbered to share with the.
Okay.
Because I don't think I got the right one up on my end, anyways. But let me see what this is. I do have the one that I made for the quashing a warrant for you.
Oh, I have that one too. Okay, we both got that one then. I don't know. Either one of us. I'll just share it. Okay.
Yeah.
And
so basically, when we're creating a dismissal or grounds for whatever reason, from a warrant to requesting a dismissal or grounds or any kind of type of objection, the first thing you want to do on your document is make a list on the side of a defendant's list, and then you're going to always be a plaintiff in the document. You got to make that clear when you file any documents from now on. You have to be the plaintiff. They don't like that in the clerk's office in the court system when you flip it around and show the wrongdoers as defendants on your document and you as the plaintiff and a claim designated beneficiary of the Constitution, which is the iron contract that basically is like a warranty on a car, but it's your warranty, and basically you're just exercising your warranty on the issue, whatever issue that you're fighting. Um, I wish I can scroll down on that. You got it on the screen.
Oh, I can scroll. You just let me
Okay.
know. I'll
Yeah, scroll it down.
Mhm.
Scroll down to so on the top part, you want to make sure that you're listed as the plaintiff and they're the defendants and the wrongdoers. And you go down to
Yeah, here's the plaintiff. Yeah.
Let me man, I wish I would have printed these out and had them right here in my hands instead of
I know I only got
see.
one of them printed out. Only that I got to look for it to bring it up. So
Okay, so what I'm going to do is I'm going to go down. Okay, so I'm going to go right down to where I'll start at where this document I created. Now this is I'm on the request quash for the warrant and request a dismissal, request for
right.
relief and discovery and findings. So that's the one I got pulled up. So I guess I'm going to discuss that one. So basically, once you get the format figured out and you know who your defendants are, you list the defendants, you are now the claimed designated beneficiary under the U.C.C. code 1-207, 1-308. You do that format. You can see the picture how I did the format on that. And then if you want to throw in a little opening statement like I did, and I'll give you an example. I started out with an opening statement it says, the opening statement for the plaintiff. You know, I'm speaking for the plaintiff and helping them write in this paper form. And I say, may it please the court and the chain of command and the sheriff's department, the attorney general's office of the state of whatever state the issue is, can say Arizona, Montana, whatever the sister state it is, and investigate institutions shall be requested to the checks and balance for some capacity of depriving, ignoring, diminishing constitutional rights and dishonoring oath is subject to a lawsuit under Title 42 U.S. case law. So I throw that in an opening statement just to throw a scare tactic out. And then I would continue saying, I, Dwane Eugene Kirkland, an Overwatch witness, with no evil intent but to protect and preserve our oath and honor the constitutional protections guaranteed by the 14th Amendment and all other protections that all judges and lawyers and police officers and sheriffs are bound to by the Supremacy Clause and the Bill of Rights. And then I go into Overwatch, have read the discovery. Basically, I'm saying our teams read the discovery and the history and the pain and suffering letters that I request from the people that contact me. And along with other American citizens that know the basic laws versus the fake laws, legislative fiat, conflicting laws, they assist me on looking over the pain and suffering and looking at the discovery. And then who are very knowledgeable of the actual law versus the code, statutes and regulations and proclamations, and any bill of paying and bill of attainder, and any illegal orders from anyone who does not have a oath or office and seems to scuttle the constitutional merits and the merit and ladder of the law. And I continue on. This is basically still in the opening statement that I write for somebody. It says, I have come to the findings and facts of the violations against the plaintiff, the U.C.C. 1-207, 1-308 without prejudice. Relevant points. Violations to suppress a warrant or affidavit to be quashed or closed or dismissed. We notified the sheriffs that are under the oath to be bound to the protection. And let's see, I got a little typo over there. It looks like bound to the protection. American
of the
citizens
American
from
citizens. Yeah.
the legal warrant of frivolous charges, conflicting law, and without no actual legal lawful jurisdiction and justification of the real law. This is an awful long opening statement, huh? This is, when there is no actual victim or property damage, this is a civil issue between the private person, the claimed judge not following the real law, and his powers of the granted enumerated judicial powers. It says, and the violations of many fundamental principles and amendments, provisions, articles, declarations of rights at a state level and federal level. By the issuing of a warrant for traffic infractions and turning it into a crime that the state can't do, nor a judge or anyone under the oath of office can do that, basically. It's not supposed to, but they do. This would be a crime for operating under the color of law and high felony treason against the people, we the people, and one of our people, a claimed designated beneficiary of the protections you promise to preserve and protect. So I'll continue on here. Let's see. When clearly there is no victim or property damage, we will further issue letters to all proper institutions to investigate the plaintiff's pain and suffering and the criminal acts brought upon the victim by police and judges and lawyers who clearly are operating under the color of law and the RICO tactics and schemes using the law enforcement to and for leverage to make one contract with them on the corporation side that is also a violation of separations of powers. Clearly, the institutions and listed defendants gathered to fish and create a crime against the plaintiff when there is no actual victim to cross-examine and that has filed an affidavit of a complaint and injury. So basically, most of these infractions and incidents that people are going through, there are actually no victim or property damage. It's just a basic traffic infraction, and they're arresting them for codes and statutes with no actual victim. So there's a whole bunch of ways that's conflicting. So our team witnesses
Definitely.
across the nation specializes in exposing judges and lawyers and police officers behind the scenes. We share our findings in a timely manner to give the opportunity to correct the omissions and fiduciary acts stated in the assurance papers and under the oath of holding offices of omissions of errors and charters of powers of the corporations and franchise according to the Public Act and granted powers. That all government institutions, city, county, town, and state are operating under the granted delegated authority by the people they serve. Says we hope that we have given proper time to make the corrections of the wrongdoing so that corrections can be made, and for the record, at a state and federal level, whoever violates the separations of powers and commit crimes during due process and investigations to harm individuals and violating and utilizing repugnant laws, and whoever diminishes and takes individuals' rights away. We believe that the provisions and the declarations of one's rights and for the nation to be in harmony with the Bill of Rights and all sister states in the matter of amendments and articles of the constitutional contract and the provisions in amateur prudent constitutional law and common law, and no other. We believe in the laws that conflict with the actual law is void and null, and we help individuals to make such claims according to law do not have to take it to court, but submit an argument so that matter can be closed. To renew a new relationship with the public and government institutions operating according to the real law without any conflicting issues, says due to the merits of the findings and facts, we request to quash the warrant and now question the jurisdiction of a legal lawful determination and authority over the plaintiff and request to not arrest the plaintiff, this readdress and grievance to the listed defendants for the record and findings. This matter should be closed and let the plaintiff pursue life, liberty, and the pursuit of happiness without further encroachment and infringement by the institutions that are to know the law and protect the actual law. Says the institutions that use military tactics and force one to contract with even though we the people are supposed to have the free agency to choose if we are not harming any other fellow American citizens and their protections. A compact agreement between the government, institutions, and the people, we the people, one of the people, to consent by contract and full disclosure for both sides without any trickery, stealthy governmental schemes. Man, this opening statement is really long, wasn't it? It's almost done here.
Yeah, but it's really good because it really addresses a lot of the issues that have been happening to a lot of people over the years, and they don't know how to fight back. And so this
Right.
is
Okay.
really,
Well, we're getting to the part where the closing on the opening statement here. It says, "We request you to mitigate the tension between the people of our great nation and to ease the pain and suffering caused by the defendants and all institutions operating under the color of law, either by a Zoom hearing or public hearing on the social network and with 2 or more witnesses." So there, I'm trying to sneak the 2 witnesses or more in there because they always try to block that automatically. Okay, so
that's
we
important.
request. It is, and we'll probably go over that a little bit here further, but we request the sheriff office, the chain of command, to uphold the oath and not arrest people for no victims or property damage or violation of the oath and protections. We all are bound to. Says we ask this warrant to be quashed and dissolved and denied for the fact delivered to you this writ and notice to be called off for scare tactics and active military estoppel actions brought upon the public and the plaintiff. The plaintiff's name and the code behind it, U.C.C. 1-207. Now we can get into the numbered facts.
Okay. Well, one of the things I'd like to point out right here, when you brought up the life, liberty, and the pursuit of happiness, now what has happened is I've had my transportation taken from me. I don't have any way to get to the store for groceries. I don't have any way to get anywhere. And all the resources to not only pay what they're asking for, but also to be able to get my vehicle or my conveyance out. You have to use the right terminology too, which is really crazy. But
well,
anyway, I just want to put that out. It really messes life.
They do. They destroy your life. They make. That's why it's important when it's really. People need to know this. You have to take that emotional stuff that happens to you, and you got to put it on paper. First of all, you got to do a pain and suffering letter, because your pain and suffering letter is your gold. But regardless of everything, that's your gold. It's showing what they've done to you and how it hurts you, and that's where you're going to get them. And then when somebody authority reads that, if they have any heart whatsoever, any empathy or sympathy, they're gonna do something right most of the time, and that's what's happening. Most pain and suffering letters do help.
Yes, and I have a son who has special needs, and he's just freaked right out. All of a sudden I'm going to be arrested or something like that.
There's a lot of us that no matter what end up going through that, and there's some cases that win and some cases that lose. But it seems like even though you win some cases and you win and you get your freedom back and you get to travel regardless if you got a driver's license or not, you're always going to run into an officer out there or somebody that's going to disagree with you. And it's like starting all over again. You got to go through the whole battle again, over and over, it seems like. But on your situation that you brought up when it comes to them taking your car, a lot of times if you actually write a letter to the prosecuting attorney with attached pain and suffering, a lot of times some of the attorneys are good enough, they'll release your property back to you and give it back to you as long as there's no victim or property damage involved. Because traffic infractions and their so-called codes and conflicting laws, statutes and rules and codes, they're not real law. And if you don't question it and know how to question it in a timely manner, they're just going to do whatever they want to you. So you have to read the documents they send to you. Don't ignore them, object to it, and then use the 9 pages of constitutional law that's withstanding in a court of law to your advantage and to fight them in a timely manner. But you always have to object. I'll give you an example on how I got it. Yeah, you got to object like
right now publicly. Okay, go ahead.
Yeah, you got to do it. But honestly, you got to drive a wedge between them. First of all, right off the bat, you have to drive a wedge between the judge, the clerk, the prosecuting attorney, and the public defender. All of them. You got to drive a wedge between them. And there's ways to do that. And you have to do it by writing. And you got to use the Constitution to drive that wedge between them. And that's how I do it. I'll write them and tell them, hey, I'll throw an article in there or an amendment or something that was violated. But the main one you want to use against a judge and an attorney is 2 main ones that I stress to anybody that's listening to this. It would be Title 18 U.S. Code, Section 2381. Do you remember me mentioning that one to you?
Oh yeah, I'm familiar with that one. That's the color of law one, isn't it?
No, this is the one where it says, in the presence of 2 or more witnesses of the same overt act or in an open court of law, if you fail to move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason. Ooh, that's heavy. There is very, huh?
That's wow.
That one's very powerful. It's short and sweet. And now here's the other one I use when I drive a letter in the wedge between them, when I try to shift the burden of proof on them. Basically, driving the wedge and shifting the burden of proof is you object and you say, hey, look, we're not here yet. Here's where we're at. Your Honor, prosecuting attorney, public defender, here's all the wrongdoing of all of what you guys are doing wrong. And you notify them, this is what they're doing wrong. And you have to, and you got to put it on the record. If you don't put it on the record, you ain't got nothing. And you got to have your own good records to have proof for when you go to an appeal. Because when you go to appeal, if you don't, they're going to try to take it off the record no matter what. Anytime you fight them and you're using the Constitution and you're winning against them, they'll take it off the record. They always do.
That's true. I know somebody that they did that to in California.
So you got to keep your own good records and have it on appeal. But when you go to an appeal, you got to focus on the amendments. You got to focus on the provisions and those 5 basic things that I said to you. Those are the only ones that can open up the threshold door on an appeal. Is fundamental principles, amendments, articles, declaration or articles, provisions, declarations of rights at a state level and federal level. So what I mean by that, you want me to give you an example?
Yes, that's helpful.
Okay, an example would be, say for a fact they violated the 4th Amendment, okay? And anybody, if you read the 4th Amendment, it says a right to be secure in your house's papers and effects against unreasonable search and seizure shall not be violated. And it goes on and on, about affirmation and issuing a warrant with somebody swearing to it, basically so many words that was harmed. So when they violate, I have a brain cramp on that. What was this? The warrant. What was I trying to focus on there now? I lost it.
Shoot, I just dropped. It just dropped out of my head too.
Okay.
I don't know if that's frequency or what, but it did. I was.
I lost my point when I had the thought, but it'll come back to me. Okay, well, let's go back to Title 5 U.S. Code. Here's another short one under the withstanding law, supreme law that's in withstanding in a court of law. This is really short and sweet. Listen to this. Anytime you know that they violated the 4th Amendment. Okay. Now I remember.
Oh, that's what. I know. Now that's what we were talking about.
Yeah, I knew it would come back to me. I lose it for a reason. So, but we were talking about violated. In comparison on the threshold questions to get into an appeal, the doorway to open to get into the appeal, right? Exactly. So the way to get into the appeal when you file an appeal is you have to have one of those major violations. And that would be an amendment, provision, or the 14th Amendment, or one of the amendments, provisions that's got to be violated. So let me give you an example. If you use it at a state level or if you use it at a federal level. I gave you an example of the 4th Amendment at the federal level, right? In the Bill of Rights, the 4th Amendment. Now, if you go to Arizona's 4th Amendment in the Declarations of Rights, or if you go to Montana's 4th Amendment Declarations of Rights in their Bill of Rights, each state has it, remember? They all have it. They're all in harmony. But in one of those states, it's under Declarations of Rights at a state level, you have the 4th Amendment. It'll say section. It'll have a section and then a number. And you read it, it'll say the same thing that the Supreme Law says on the 4th Amendment. The right to be secure in your house's papers and effects against unreasonable searches and seizures. Okay, so the point is one of those will have to be to get your door unlocked. It's like the keys to unlock the door to open for an appeal. It has to be one of those violations of what I said. Again, amendments, provisions, articles, the 14th Amendment, the Declarations of Rights, or at a state level or federal level. That unlocks the door, okay? Or even titles, like this Title 5 U.S. Code section 556, section 556, 557, and section 706. Look how short and sweet this one says. And this is supreme law of the land. This is constitutional law. And it's actually, this is what it says. This says, courts lose jurisdiction if they do not follow due process of law. So if you can prove any way with 2 witnesses or a witness, even a recording, that they violated any of the due processes clause, due process is the key point. And due process clauses in the amendments, you got the 5th Amendment, you got the 6th Amendment, you got the 7th Amendment. Basically, any amendment would be considered due process clauses as far as I'm concerned. But they do have specific due process clauses for violations, right?
Right.
So if they violate any of those, and if you bring it up and you know this right here, you can say, Your Honor, I object, and you put it in writing, file a motion. You already questioned jurisdiction at the beginning, right? You already questioned jurisdiction.
Yes.
Hey, you don't have jurisdiction. Go ahead.
Something else. I don't know where this would come into play, but Miranda rights. I thought anytime somebody was going to arrest you, they were supposed to read you rights.
They're
that was
to,
even right there in here in Arizona is where that originated from.
Yeah, you see that would open the doorway to get into the appeal process right there by itself. And in my readings of actual constitutional law, it does say you can't enjoin them, but it seems like people do enjoin them. Let me give you an example. What the way I like to outline it in an appeal is I'll throw the 14th Amendment right on the top, because if you read the 14th Amendment, it says the 14th Amendment says that's the guarantee of the equal protection of the law, right? We're all guaranteed the equal protection of the law, according to the 14th Amendment when you read it, okay? Now, that's real broad, right? They can violate you in so many ways, right? So now you can put that on the very top. You put that on the very top, and you can say, well, they violated the 14th Amendment, and they didn't give me the equal protection of the law. And you can say, well, the question is what did they violate? Then you can go in and say, well, they violated the Fourth Amendment. They violated the Second Amendment. They violated the not very often the Third Amendment's ever been violated very much, but it's actually starting to happen now. But they violated the Sixth Amendment. They violated the Seventh Amendment. You got to read them to know what they say in order to say that they violated it. And then you got to plug your situation in of what they did to you onto what they violated. So you got your 14th Amendment. I'll say one or two amendments they violated. And then when you go in there, you say, now they violated that. Here's 1 through 10 of what they violated. Now, because they violated that and I got proof, I'm going to use the Title 42 U.S. case laws that says if there's any capacity of violations of the Constitution, period, now they're subject to lawsuit. And it tells you the cases. It gives you 1986 cases. There's about 4 of them. It's in the documents that I got in. I think it's 1985, 86.
Should I bring the document back up?
We'll probably run into it when we get further down in the document.
Okay, let me bring it back up. Yeah.
I can. I need to turn I should have turned the dang backlight on. Hang on, let me turn this light on back here.
Okay.
Let's see.
I know lighting can be a pain sometimes, especially I had a bulb that I used to use all the time, and it flew out, unfortunately.
Be a bright light now. All right, so now I can see a little bit better. I'm sure glad this is a first test run here.
Okay, well, we are live.
Yeah.
But that's okay.
Okay, I'm going to read this to you. What it says on that Title 42. This here is the really important. This is where you're going to sue anybody for violating your rights. It says Title 42 U.S. Code, Section 1983, Section 1985, and Section 1986. Here's what it says. Clearly established the right to sue anyone who violates your constitutional rights. The Constitution guarantees he who would unlawfully jeopardize your property, lost property to you, and that's what justice is all about. So no matter what they violate, this right here says under Title 42, that's what lawyers use to actually for the lawsuits. And that's under constitutional law, that your Constitution is an ironclad contract enforceable in a court of law. Wow, that's amazing. Attorneys know that, but not very many people know that,
Well, they don't parrot and use it that much, do they?
No, every case that's a lawsuit, that's what's used nowadays. That's how they get their cases, under that.
Oh, I see. Okay.
Okay, so we can either go back to that document and go down and break it down and elaborate on stuff, or we can just continue on the real major stuff here.
Let's go through you have all those numbered things we can talk about those
Okay, let's
facts
do that.
collected.
That sounds good.
Yeah, because they're all relevant. This one does.
I know they're all good.
Yeah.
All right, do you want to do you want to go to facts collected and go over some of those?
Yeah, that's what I was going. Yeah.
Or do you want to pick one? Do you want to go scroll down and pick one, and we can discuss it, or we can just continue on like we're from the reading?
Let me just kind of scroll a little bit.
Because if I'm just reading to people, it's going to bore them on it. But
yeah, they get bored. Yeah.
We can elaborate on. But they are short and sweet and blocked, ain't they? Though they are short. Let's see.
Yeah, they are pretty short. We could do the first few.
Let's go down to the document that I create. Here's what I created on this document that we said we're looking at. I will go down the facts collected, and I'm going to read number 1. So I got it designed for the public to be able to just fill in the line like an application. They can read it, and then they can just fill in their name in the missing in the
blank
where you can write your name. Yeah, the blank. It says the plaintiff. I'm going to use an example of. I'll use my name in this. I'll say the plaintiff, Dwane Kirkland, requests that the prosecuting attorney that has the burden of proof. He, the plaintiff, requests a legal, lawful determination of jurisdiction and a legal determination of the collections of illegal evidence that the institutions involved violated by the fruit of the poisonous tree doctrine, and a legal determination of the breach of the constitutional contract between the people, we the people, that the government institutions promised to govern by. So basically, what you're saying to them is they violated your contract. You're bringing it to their attention. But before we go any further, I question jurisdiction right now on writing, and by this document, you're requesting jurisdiction, and you're asking them for legal, lawful determination of jurisdiction. And I guarantee you, if you stay focused on this alone by itself when you're in court and you demand a legal, lawful determination of jurisdiction to the prosecuting attorney and ask the judge to give him 10 days to answer it, if there is no victim, no property damage, and there's no elements of a crime, you have basically, they can't prove they have any jurisdiction and authority over you unless you consent to it and waive your rights by waiving and signing your rights off, as the judge usually tricks you at the beginning. That's the truth, people. That alone is so powerful. That right there can get your whole case dismissed within 2 weeks' time of arguing with them over jurisdiction, because that prosecuting attorney cannot prove jurisdiction. I guarantee you there's no laws that show that he can prove jurisdiction when there's no victim or property damage. He has no jurisdiction. It would be considered a civil issue, a contract issue. So that's very important.
Yeah.
So remember that.
I
can give you an example on that, but I'm going to, I lost my spot. Let me go back down. All right, we're going to go to number 2. So remember how important jurisdiction is, okay? That's if you know you don't have a victim, no property damage, or no person that you can cross-examine if you actually go to court, to the 7th Amendment court by your peers. If you don't have a person you can cross-examine, you have no case, period. You're gonna question the invisible man. They're going to bring the officer up, and they're going to say the state is the one you offended, but you got to flip it around and say, hey, no, wait a minute. I am the state. I'm one of the people. I can't go against myself if I'm the state. I'm one of the people of the state. Right? Does that make sense?
Yes.
So that comes to that point of the plaintiff and the defendants, right? Okay.
Yes. But what they usually say is, they start pointing out statutes and codes.
Right. Well, then that's when you object. And remember me telling you the process on an objection on a code that's conflict of interest? You want me to tell you that, go to that real first, or do you want me to continue on to this other part?
Well, maybe we should just continue on, but we'll come back to that.
Okay, just real briefly, real quick. Anytime they're using a code, statutes, and fake law to justify their actions, you just have to object and file and demand for a declaratory judgment. Okay, remember that.
Okay.
And that's under your constitutional law. It's called declaratory judgment. And if you want the actual law on that, I have it right here too.
Cool. Send it to me. I would like to see it. Maybe some of these things I might be able to add
Okay,
to
I'll
the description.
just real fast. Here, just real quick. It says, no one is bound to obey an unconstitutional law, demand for a declaratory judgment. Okay? So if you believe the code and statutes is a conflict of interest and it violates your rights, under 16 Amateur 2D Section 177, that's what you would file an objection under, okay? And then it gives you the definition of it. I'll send that to you. So, as a matter of fact, you got the 9 pages of that we're discussing. Okay, so we're on number 2, or
yeah, we didn't go all the way through it. Yeah, you were talking a little bit about how they trick you into waiving your rights, but anyway,
yeah.
go ahead.
Okay, well, first of all, I should tell you how they do that. You want to know how they do that?
Well, I think that's important because that's like non-disclosure, and they create a contract anyway.
Right. Because people don't realize what they're doing when they're standing in front of the judge. They're nervous. They don't know what to say, and it's scared. Now, based from my experience, this is what's going to happen. What you'll come up there, the judge won't even let you talk or say anything right off the bat on a traffic infraction or an issue. Okay, the judge will just read off your charges, and he'll ask you, "Do you understand your rights?" That's all he's going to do to you and say to you, and then you're going to say every time. Most people say, "Yes, Your Honor, I understand my rights," and he goes, "Okay, you understand your rights." He'll take that little paper that's in front of him.
Wrong word.
Yeah. He'll slide it across the bench, and he'll give it to the sheriff or the clerk or whoever's there, and brings it over to you, and then you sign it, right? That's where he tricks you. As soon as he gives that to you, and you sign that document, you don't even realize it, but you just signed a waiver to waive all your rights, and you just waived into their privileges and their contract. So whatever you do, when the judge does that to you, right off the bat, there's 2 ways you can do this. You can say, "Your Honor, can I ask a question for the record?" And he'll grant it to you, and you say, "Okay, what's your question?" You can either trick him that way, or you can not sign the document and say, just sign the document with a code under duress. You just put UD in your name, and you're saying you're forced to sign it. They don't have the time to look. They just make see if you sign it. But if it does say UD under duress, you can come back later and say you was forced to sign that, and you can argue that alone.
Okay? I have another little code that people can use, and it's VC or VI. Both of them mean, one is VI is the Latin version, VC is the English, but it means exactly what you said, under duress. It's
but they have under their own U.C. The court's already operating under the uniform commercial codes, okay, that you're in there for the infraction, right? So they're operating on the uniform commercial codes already. That's admiralty, merchant, commerce, C of the any fictional court. That's all it is, okay? So when you sign U.C.C. 1-207, you're basically telling that judge, "Hey, look, I'm signing the document because I have to, but I'm not waiving any of my rights," and that's what the signature says. So a lot of times, if you actually sign that and you slide that back to the judge will pick it up and he'll look at it and he'll see and he'll say, from my own experience, what they said to me when I did it, he goes, "Do you even know what this means?" And I said, "Yes, Your Honor, I know exactly what it means." I said, "Would you like me to explain it on the record?" He goes, "No, you'll get your trial." And it stopped right then and there on that. And he did his, the code told him that everything he's going to do to me, I'm not waiving my rights. He has to construe everything to the Constitution under the 9th Amendment and any of the amendments that I claim under the protection of the ironclad contract. Period. Okay? Now, that's the one way of doing it. The other way is from experience where I actually got it dismissed. I actually questioned the judge right off the bat. When I was in there, she read me my rights. She read me she asked me, she went through the whole protocol, right? When you're in front of the judge. And then she goes, you read me the charges. And she goes, "Do you understand your rights, Mr. Kirkland?" And I said, "Yes, ma'am, I do." And she goes, "Okay." And then before she can slide me the document to me and have it handed to me from the sheriff, I said, "Your Honor," I said, "can I ask you a question on the record?" And she goes, she smiles, her eyes rolls back, and she says, "Mr. Kirkland, yes, what's your question?" I said, "Your Honor," I said, "if I don't sign your contract today, are you going to put me in jail?" And she flops back and she says, No, Mr. Kirkland, I'm not going to put you in jail. I'm going to put on here that you refused to sign. That's all. And she said, okay. I said, okay, fine. I refuse to sign. And she goes, okay, well, I'm handing all your documents back to you, Mr. Kirkland. Your dismissal, your grounds, all these papers that you filed. Says you need to go now take those to the prosecuting attorney. And I said, Your Honor, I said, I'm going to take my documents. I got copies right here. I'm going to take them to the prosecuting attorney, which was just right down the hall from right where her court is, down the hallway into the courthouse. And I was going to take it to the prosecuting attorney. So I went to the prosecuting attorney. I went in there, filed my dismissal, grounds, and all my paperwork, and I left. I got a letter in the mail 2 weeks later. Are you still there?
Yeah, I'm here. I just,
Okay.
because you're talking, I just put you up there.
Okay. I'm sorry, but I just got to tell you a life experience that actually happened. Sharing with
No, that's great.
Yeah.
That's fantastic.
So I went to the prosecuting attorney's office, filed the paperwork. 2 weeks later, deputy attorney wrote me a letter, and the judge wrote a letter back saying, Mr. Kirkland, we deny your dismissal on your grounds. Okay. And I immediately went down, sat down to my desk, typed up a response and an objection to their denial. I wrote a denial for their objection. And I sent it back. I sent it back with the grounds, right? And when I sent it back, I got a letter within a week and a half later from the deputy attorney stating, in the interest of justice, we're dropping and dismissing this case. And they dropped my case, period. And it was over with. So I won. But see, the thing is I still notified the deputy attorney's boss. The attorney of the county was Fulbright in the state of Montana. I still notified him of the deputy attorneys and gave him I actually sent a complaint in to him about all the violations. So whatever I sent to the head attorney, he went and disciplined his deputy attorney. And then somehow the deputy attorney decided to file a dismissal in the interest of justice, and the matter was closed. So that was one win. One of my wins that I got was really awesome. And actually on my webpage, you can see me holding some papers up where it's silent. I'm not saying anything. Those are the documents I think was either on that. It was on that case, that particular case that I was holding up and showing the dismissal on the picture of that. So that was pretty cool. I'll never forget that. So there's a lot of things like that that'll pop up back in my mind that I could share you from real life experience. But anyways, you got to stop them right at the beginning. Okay, so I hope a lot of people understand what I'm saying. But let's get back to the next thing, number 2 or 3 on that document.
Okay.
Let's see.
It took me off the screen. It's not letting me come back on.
Yeah, I'm trying to find. Okay, so so we went over number 1 and number 2, basically, right? So on that document.
Yeah, we're going down. Well, I don't think we went through all of number 2.
Okay, let me go back up to. Let's see.
I'll read it for you, and then we can go on to the next one. Then explain how they violated what happened. The plaintiff was denied the equal protection of the ironclad contract and forced to an unknown contract and tricked into waiving rights in the past from an attorney lawyer who was part of the union bar and contract between lawyers and judges in the past. Without competent attorney and counsel, and or he or she was not educated himself to question jurisdiction or any other of the merits involved in this matter. That's number 2.
Okay, what number was that one? That was which number?
That's number 2. That's number 2.
Number 2. I don't think I must have lost the. Let me go. I must have lost the document. I got a different document for some reason. Let's see. Okay, here we go. I found it. Okay, so that was number 2. What part do you want to discuss? You want to, and I can elaborate on.
Well, about the part of the union bar and contract between lawyers and judges. I mean, I think that's kind of important.
Yeah,
because it's like 3 people against 1. You got the court against you, you got the judge against you, and you got the prosecuting attorney against you.
That comes to all that part I was telling you how I can show people to drive a wedge between them. You got to send your documents and that we create, like this document. You got to send to one of them to drive a wedge between them and have a complaint. And here's the trick. You ready for this? To drive the wedge between them, that bar. First of all, the attorney that's part of the bar is actually already under a different oath with the judge and the judicial system. They're not obeying our oath of office that they're granted powers coming from, but they're obeying the British oath for the bar associations. It's actually a union. There's a lot of material about that. They say that attorneys are actually spies from different countries that come in, go to law school, and keep us enslaved. There's a lot of things out there that say that. But to make it really simple and easy, the bar is headquarters out of Great Britain, somewhere in Great Britain. It's the bar, British something, it says by the acronym and the initials of the bar, BAR. So it's British Attorney something. I don't know the exact same of it, but that's what a lot of people claim. And the proof on that I've seen is based on their actions, because they go by their collusion together to gang up on you on the codes and statutes and regulations. Makes me, anyone that violates the Constitution as a soldier, ex-soldier, to me, they commit high felony treason under Title 182183. That's just me. That's embedded in me, and that's what was taught in me in the United States Army. So that's why I'm so picky on when people violate this stuff. To me, that's high felony treason, and that's punishable by I don't want to say it, but it's punishable by the way the law really reads. You have to read it to see what it says, and you're going to believe what it says. I'm not going to say what it says, but I'm sure you can assume what it says. It's military.
Oh, something to do with your neck? Is that what you mean?
And believe it or not, just on social networking, they just arrested one of the Department of Treasury people for illegal bill of attainers and money going over to Ukraine right now. The Army went in, they went through the Army military courts, and they went and arrested that government official for laundering money. So they just arrested her just not too long ago. So that's
Yellen? Yeah.
Yellen. Yeah,
Janet
that's exactly who it is. All right, but anyways, so that gives you a little bit about the bar association. To me, they're spies. They're committing treason by their acts of breaking down our laws and enslaving us and obstructing our freedom. Okay, so let's jump down to number 3. Go ahead and read that one, and then we'll continue on, and then I'll elaborate on more on that. So
okay, number 3, the listed defendants' institutions violated the 4th Amendment and the 5th and 6th Amendments. The declared charges codes that conflict with the contract of the plaintiff due to the facts of not in harmony in the history.
Okay, so that right there is basically the code, statutes, and regulations, and the justification they want to charge against you, whoever this person is in this document, me, you, or the person listening to this, whoever writes their name in this. When they violate any of the 4th Amendment, if there's anything they did to you that violates any of the clauses when you read it. That's why it's important that you have to read the amendments, the declarations of rights. I mean, at a state level. Okay, I'm going to say this again. There's 5 points that I stress to people that you need to at least read. If you don't read the whole Constitution, at least read the Bill of Rights, okay? Read the 14th Amendment and know what fundamental principles is, know what the amendments are, know what the provisions are, know what the articles are, and know what the declarations of rights are, okay? They all say the same thing except for they're numbered to trick people that can't read or that are ignorant, okay? So once you got that locked in, you can say, okay, they ripped me out of my car, they pulled me over, or whatever your situation is, you plug it in, you read it, and you say, oh, they did this to me, it violated this, it violated the 5th Amendment. What does it say in the 5th Amendment? Well, they pulled me out of my car, arrested me before they gave me any due process. So they locked me up before an actual crime, before they even said I did a crime. So that's a violation of the 5th Amendment, right? So there's your argument. They violated the 5th Amendment. And then you can go back and say, well, if they violate any of the amendments or any of that stuff, they're basically committed a crime under Article 6, Paragraph 2, and the stuff that I pointed out to you. But anyways, I hope that people understand, and that's what I'm trying to get at is you got to read the 5th Amendment, you got to read the 6th Amendment, you got to read the 4th Amendment, and whatever clause in there that you plug your situation and they violated, they are wrong. They violated their oath. They dishonored their oath. They committed high felony treason. They're subject to high felony treason charges. They're subject to titles under Title 18, 241, 242. There's a whole list of stuff they're subject to because they violated that Fourth Amendment, the Fifth Amendment, the Sixth Amendment. But you got to declare it. You got to put it in writing. You got to object to it. You got to bring it to the attention. But if you don't know, then how are they going to know? Right?
And that's the other thing that I actually neglected to put in my criminal incident report, and that is that they never read me any Miranda rights at all. They just arrested,
Right. That alone right there is that alone right there. Anything collected and whatever they bring into court to use against you, Gaia, you basically, in an evidentiary hearing, you can declare under that doctrine. When the earlier reading, when we were talking about the doctrine of exclusionary evidence collected,
yes,
it's the fruit of the poisonous tree doctrine. So basically, in an evidentiary hearing, alone can be argued that illegally collected evidence alone by itself by the violation of the Fourth Amendment. So that can be utilized, and then if you suppress the evidence collected, then they don't have any other charges of whatever they created, whatever they found in your car. They found weed, guns, or whatever, controlled substance, pipes, whatever contraband they have a code on to go after you. Anything collected in evidentiary can be dismissed in evidentiary hearing alone. So, but that's if you have a good attorney, and a good person that knows how to do that. So, all right, we're going to go down to number 5. Go ahead.
Okay, let me get back over there. Number 5, all listed unconstitutional acts are now declared and expect bonds from all parties involved who committed a crime to create and fish for a crime against the plaintiff, the subject matter. No victim or property damage or elements an actual crime with the proper process of an affidavit, and that the swearer by witness to the matter. And then it says in the pre-hearings and omnibus hearings.
Yeah. Okay. Let me start with the omnibus hearing first, since you brought that up at the last part of it. An omnibus hearing, an attorney will tell you, Mr. Kirkland or whoever the name and subject matter in this letter, you don't have to show up. We'll go to the omnibus hearing for you, the first hearing. Don't worry about it. You are now appointed at the public defender. Public defender will tell you not to show up, and he'll go in and basically, you don't show up, he's basically already entering you into their contract. So I'd advise you to show up at any hearing, omnibus hearing. In the omnibus hearing, I actually wrote an article, and it made it on their definition of wiki dictionary, that wiki dictionary. I elaborated on the omnibus hearing of that's when the time you actually bring up your constitutional issues to the judge and the prosecuting attorney in your omnibus hearing, so it can get thrown out right then and there. They put that in there. I wrote that. You have to look that up. I have to show that with you one of these times. But
yeah. Well, I'm going to be studying all this anyway. I'm working on it. I mean, for me, it's a review because I've
so basically
before. And
if they tell you if the attorney says your public defender tells you to not show up, don't show up. He tells you don't show up. He's basically taking control of you, and you're a retard, like a child or something, or ignorant, and he's going to be. He just became your POA, your public defender, basically. So you want to bring those issues up right at the bat, and then you want to get into the jurisdiction and the contract issue right at the bat. But anyways, a lot of times those attorneys will bail on you when you start doing that stuff. But there's a document I created for that alone. That's another whole reading that you can give to your public defender and make him sign it. If he doesn't sign it, then they'll issue another attorney. They have to go. Then they're violating the due process clause of your guaranteed protection of an appointed attorney. So there's tricks how to get rid of an attorney that's not working for you, which I can share that in the future for people. But anyways, let me finish up on this, what you read. Parties involved committed a crime. Okay, we know they're always trying to create a crime for equity. We already know that, right? Because that's their whole motive. Is
like everybody says, they stack the charges.
Right. They're doing it for money and equity, and they know you're not smart enough to question it. And half the times nowadays, the attorneys are not really smart enough to even question it, honestly. Okay.
Wow,
so
that's
that all goes right back to The main objective, we want to know, there's two case laws that you'll find out in this document, in this paper, when we get further down. I talk about, right here, it says, no victim or property damage or elements of an actual crime with the proper process of an affidavit. Now, there's two major missiles in this sentence right here that I just said in this statement right here. All right. When it comes to an affidavit has to have a person that swore to it by oath saying you harmed them and you damaged them. Okay. So if it doesn't have that, it's not a true affidavit. It's a fraudulent affidavit. So remember that. That's an argument alone that you can bring up. So you always want to look at the discovery, look at the affidavit, see who signs it, see if there's somebody that swore to the charges that they were hurt. If there is none, it goes right back to the elements of crime. The elements of a crime can be dropped because you're missing the main element of a crime. There's 4 elements of a crime in actually law school. They teach attorneys and basic for studies of law. There's 4 elements of a crime. The main element of a crime is a victim or dead body, or basically a victim, right? So if there's no victim, you have the main element of the crime missing, and you can argue that alone and say, well, you got to have 4 elements of a crime to convict me of a crime. If you're missing the main element, then you have no crime. But how many people know that? How many people question that? Nobody does, not even the attorneys. The attorneys might know it, but they won't even bring it up unless you try to get them to bring it up. So I guess I think
sometimes attorneys gotten into a pattern of behavior and haven't, really pursued things that they probably could have.
Attorneys are not on
maybe it's
side.
Lazy.
They're spies. Okay, first of all, they're not taught, or they don't teach them, just like they don't teach the cops the constitutional stuff. They don't teach it that. They only teach you what they do is here. Okay, here's what an attorney gets taught. And the reason I know this is because in my 15 years of studying and what I do here, and I'm telling you, is when I first started, every attorney I encountered, the first question I ever asked them, I go up to ask them, I go, hey, how much schooling did you go to in order to become an attorney? And every attorney that I've asked, which was only about 3 or 4 of them, honestly, I asked them, I go, how much schooling did you have? And the attorney would say, well, I went to law school and I had 2 years of contract law first, and then I went into what I specialize in. And I go, what do you specialize in? And they go, oh, criminal. Or they'll say divorce, or they'll say taxation, or admiralty, or merchant, or commerce, or commercial. So they go into what they'll specialize in. They only teach them that stuff. They don't teach them the real one that makes a difference of a constitutional law. They get maybe 1 semester or maybe even one, not even a semester, maybe 2 classes of civics, of constitutional law of government, right? And that's it. Mm-hmm. That's all they get. So you tell me if they're competent to even bring up constitutional law. Heck no, they're not. But here's one thing that I caught on that really brought my attention for people to know. The most important thing when I asked that attorney what they taught you, and you know what he said, the first thing, 2 years of? What did I say? 2 years of what? Contract law.
Oh, contract law. Yeah, that's
contract law. You can beat them alone just in contract law. And what do I mean by contract law? The ironclad contract, this constitutional stuff that I'm telling you about, that's a contract. It's still bound. It's not for sale, trade. It can't be changed.
It can't be suspended either, can it? With a so-called
no, it can't even be suspended. It can be dormant because of ignorance and depriving and people violating it, but it cannot be suspended. There's no way. Matter of fact, right here it tells you, I'm going to tell you now, I'm going to look it up. No emergency can justify to suspend or scuttle the Constitution. No economic emergency, no emergency can supersede the Constitution. Okay?
Yeah. I wanted you to say that because I had read that before, and they violated that during the whole program that went on before.
Right, but nobody knew, nobody questioned. But here, you ready? Here's your question.
Right.
Here's where you're going to fight it and bring it up under the. It's in American Jurisprudence Book 16, Constitutional Law Sections. It's called 16 Amateur Juror 2D. Are you ready?
Yeah.
16th Amateur 2D, Section 98. I'm just going to read what it says a little bit, and it says, "No emergency has just cause to suppress the Constitution." Do you hear that? No emergency has just cause to suppress the Constitution. And this is what it says. It's actually a pretty long paragraph, but I'm going to read just a little bit. It says, "While an emergency cannot create a power, and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitution." Whoa, that is powerful right there. I'll read that again. I got to read that again.
Wow.
It says, under 16 Amateur 2D, Section 98 says, "While an emergency cannot create a power, and no emergency justifies the violation of any of the provisions of the United States Constitution or the state constitutions." It further says, under the constitutional law, it says, "Public emergencies such as economic depression for especially liberal construction of constitutional powers, and it has been declared that because of national emergency, it is the policy of the courts of times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classifications of the powers of the coordinate branches of the government, and as so far as may not be clearly inconsistent with the Constitution." So basically, in so many words, anything in conflict with the Constitution, you can never go against it. It can never be negative. You kind of see, they kind of throw the words.
Using
and you
it.
really, huh?
I said people aren't using it like they could.
Right. They don't know. Again, it comes down to make it simple. That first sentence that I wrote on, that I read to you under 16th Amateur 2D, Section 98, American Jurisprudence Book, Constitutional Law. These books right here that this stuff comes out of, these books alone are worth like just a few of them are like $10,000. Who can afford $10,000 to buy those books? The judges have those books sitting behind them in their desk, right behind them in their big chair. Yeah. You'll see those books right behind them. Those are the books that tells the judge how to do their job as a judge. Did you know that?
No, I didn't. As a matter of fact, that's very interesting.
Trust me, and it is.
And that they have and they cost that much money, so people, the system is weaponized against we the people. That's all there is to it.
Right. That's so true. Okay, so let's move on. That little paragraph, we elaborated quite a bit on that, huh?
Right. Let's go through one more, and then I think what we really should do is we'll have another show or two, because this is really important information, and it's a lot for someone to absorb. They might want to listen to this a couple times.
They're going to get bored. They can't handle this stuff. This is you're right. This is not easy. This is complicated stuff. It's hard for people to believe it or even understand it. So, yeah. All right, go ahead. We'll do one more, and that's it.
Okay, which one are we on? Number 6?
Yeah, we're on number 6.
Okay, state of Montana level example of a sister state where all states say the same thing and are in harmony. Full report is requested in a timely manner.
So basically that all goes right back down to what I said about being in harmony at a state level and federal level. Remember? You remember how I said the Fourth Amendment, and then the state of Arizona or Montana or California or New York or any state you can pick, the Fourth Amendment says in their Declarations of Rights the same thing as it says in the Supreme Law of the land. That's what I mean by being in harmony. Okay?
Okay. Yeah, that's important.
Yeah, that's powerful. So if the state says it, if the Supreme Law says it, and the judge says it's not, who's right?
Not correct? The judge.
The judge is wrong.
Not the judge. Yeah, that's what I said. Not the judge.
Yeah. So if the judge is wrong, what are you gonna object on? You're gonna say, Your Honor, you're dishonoring your oath right now. You're not preserving and protecting the Constitution. What are you violating? You're violating Article 6, Paragraph 2, the Supremacy Clause. It clearly states the last sentence of that supremacy clause says you can't enforce nothing but it says in the whole clause that the judge is bound to the supremacy laws of the land, right?
Right.
It says in the first section when you read it. Then when you read the second section, the last sentence, it says the judge cannot enforce and rule on conflicting laws that are notwithstanding or that are in conflict with the supreme law of the land. So that's out of harmony, right?
Yes. Oh my goodness. I just figured out how to get back on the screen. Sorry.
Okay. All right. Sorry about that. All right. So I guess you want me to just put a closer on this, or do you want to put a closer? I can say,
well, what
thing.
Say another thing, and we'll kind of wrap this one up, but we're going to have another one. We're going to continue where we left off, because this is educational material about the Constitution and about protecting and utilizing your rights as an American. So.
Right. Okay. I want to read just for a closure. We didn't get through this whole document on this document that we created to share with the people, but we did break it down a little bit, and we got way off on track on some stuff to elaborate on, basically, so understanding of certain things. But in here, there's one thing that I want to read to you for closure. Here's my closing thought. If for some reason that you never hear from me again, if Heavenly Father takes me away and I'm not here no longer, this is what my teacher told me, and I'm going to tell you what my teacher told me. He said, this is the most important thing for you to know. He says, the U.S. Constitution, Article 6, Clause 2, the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary, notwithstanding. Again, that's that supremacy clause that I talked about.
Wow.
The first part of that, the judges are bound and they read it, but the judges and lawyers and police officers and attorneys in government fail to continue reading the last sentence.
Wow.
What does the last sentence say? It says anything in the Constitution of laws of any state to the contrary is notwithstanding. Now, if you read that and study that and break that down, you're going to go a long ways right there just by itself.
That's exactly what I intend to do. And I'm refreshing all my everything that I knew, and you have added to it. So that's a good thing. And I really appreciate your time and energy and how you have devoted yourself to this. Just as I have to putting videos like this out, you have devoted yourself to helping others, and you just take donations. Same here. So we are the ones really trying to make the changes that are needed so everybody is treated fairly and constitutionally, and we get America back the way it's supposed to be.
You know, one other thing that my teacher has said to me that I want to share, he said, you got to wave that little booklet up high. Every one of us, the more we wave it high, the more it's going to be undormant. It's going to come back up and be alive again, because right now it's just asleep. That's all. It's asleep.
It's a little book about this big, right? A Constitution.
Yeah. It's the little tiny book that you can get. And what it is, you got to contact NASA to zero in with their magnifying glass to be able to read it.
Yeah. That's about it. Okay.
That's how important it is to you. They don't want you to know. And guess what? What else my teacher shared with a closing thought? My teacher shared with me that little booklet controls every law as far as your eyes can see. And they got many miles of laws, my friends. That little booklet controls it all. And I'm going to show you how to do it. Remember that. I will show you how to control every law.
Fantastic. Thank you so much, Dwane. We're going to have you back.
Doesn't that sound crazy?
I wish it's unfortunate that Eva Marie wasn't able to participate because she was having problems with the audio and camera. But I just want to mention she was here for the purpose of letting you know that she's not a victim anymore because she studied and exercised the documents and the things that
I
she's
actually
learned.
helped her on her case. I actually helped her on her cases through quite a while, but she's pretty smart. She's very smart, intelligent lady herself. But I just helped her on how to use the Constitution as a weapon. And man, she actually went into court and kicked their butt. And then she's actually got a lawsuit on the Second Amendment issue pending, and I think it's Pennsylvania right now. And that's going to be a very good case for her. She's waiting on that to finish up. But yeah, she's outstanding, and that's just one of many people that I've helped that besides my own experience that I could share. So,
okay.
Anyways,
well, perhaps
this was exciting first test run.
Right, and perhaps on another show, maybe she might be able to have a strong internet and be able to participate. It's like the internet's okay, right. But maybe another issue. But anyway, those things get worked out eventually. And I would just like to say thank you again, Dwane. It's been an enlightening experience just listening to you and the review of the Constitution and the history of our country and getting our rights back. And we, the people, are supposed to be in control, and we need to take it back and do that. So thank you so much. Thank you so much.
Thank you so much. All right.
I'll be back. We'll be back.
Well, I hope this first test run is not too boring for people, but it's going to be boring to people because they don't understand, but it'll eventually come out to where to get better. So.
Well, Eva says it.
Plus, I get excited when I get really excited and I get too loud, but there's got to be a way we can control that. But I guarantee you, when we go process further on,
you shouldn't knock yourself for being passionate. Something that you feel very strongly
but
about.
You'll find that I'll get this. We'll find that the connection, and you'll see that I'll share true live experiences that I've been through over 15 years of what I did. There's a lot, I'm telling you, but I just can't. Certain questions, certain readings will make it click and come back to me of me helping somebody, like different cases and stuff that I've helped.
And I'd also like to point out that
thank you.
I'd like to point out that you are a veteran. You served in the military, correct?
Yes, but I'm a non-combat vet. He saved me for combat now. He saved my life. He saved my life now to preserve me to do what I'm doing to defend us here at home. I believe that.
Oh, wow. Okay. That's awesome. I believe it too.
All right.
Okay. Take care. We'll see you soon.
I will. I guess you'll sign us off. Thank you.
Yes,
I love you all. Okay.
Bye, everyone. Thank you.
All right. Bye-bye.
We have found our way. It's a brand new day, and we'll be making history. Are you with me? Won't you stay? We have come so far. This is who we are, and like the rising sun, we have just begun to play our part. This is the time we form the chorus. Lift your voice for those before us. We can rely on one another. Feel the pride, let's show our colors. We are heroes and dreamers. We are restless believers, stronger than ever. Never say never. Don't look back now. Don't look back now. Stand with each other. We are sisters and brothers, finding our place and running the race. We'll take our chance and seize the moment. Hold on tight and don't let go of all your hopes and dreams that light the way. We control our fate. Destiny awaits. We are all the actors in the stories we create. Hope will be our guide. the time we formed the chorus, left your voice for those before us. We can rely on one another, feel the pride, let's show our colors. We are heroes and dreamers, we are restless believers, stronger than ever, never say never. Don't look back now, don't look back now. Rise up, stand with each other. We are sisters and brothers, finding our place and running the race. We'll take our chance and seize the moment. Hold on tight and don't let go of all your hopes and dreams that light the way. Watch me now, I feel the spotlight shining down. Everything's alright, standing proud.
Hi, everyone. I just have some closing remarks, and that is I'm in a very difficult situation now, and I do really would appreciate any support that you might be able to provide through either donations or certain products that I have. And I'm very excited about the super patches. I'm very excited about more Mito. And I'm also very excited about Ambia Gold. Those are probably some of my most favorite products. Take a look at them. You really should try them. They're excellent, and I use them regularly. So, and then I wrote a little bit about them at the end as well, or about each product with its little description of what it is and how it works and that kind of thing. So please do take a look at that. And if you're able, I sure would appreciate it if anyone would be willing to make a contribution. And I also would like to send a donation to Dwane. So anyway, thank you, everyone. I'm going to close this off now. I hope you enjoyed this. This is very educational, and we will have another one or two, whatever it takes to get through the documents and the information so that it's educational for you all. Thank you very much. Much love.